The Child Protection Bill was put under the microscope today with presentations from three sections of the society: the church, a political party, and the legal fraternity. We're joined now by Wendy Burke, who tells us the session centered around definitions, adherence to international conventions, parental rights and responsibilities, as well as a wide-reaching scope of the bill. Good evening, Wendy.
Well, Ryan, the Joint Select Committee, chaired by Member of Parliament Tony Moore, heard first from the Family Faith Freedom Charity. Davida Maynard-Holligan made the presentation, and among their queries were areas related to gender fluidity and reassignment.
We ask that it be stated in the bill that nothing in this bill shall be construed to promote or encourage rights related to sexual orientation or gender identity, transition therapy, or the autonomous sexual rights of children of minor age. In closing, we recognize that our worldview is not the only one that has to be considered, but we are resolute in our conviction that our Constitution and our laws must reflect and protect the supremacy of God, and that Barbados must remain a God-fearing nation.
Select Committee member Trevor Prescott wondered whether or not there was still time for Barbados to hold on aspects of the convention.
Is placing a lot of emphasis on sexual orientation, and they're saying that there's a provision within the treaty that allows that is considered as still a legal instrument on sovereignties equally as powerful as statutory law within the independent sovereignties. Can we exclude ourselves at this point?
The Democratic Labour Party made its submission through third Vice President Felicia Dujon and Young Democrat Tyra Trotman. Ms. Trotman has issues with the way in which the word risk is used as it relates to the circumstances under which the authorities can step in to assist a child.
That word risk, that's a weird word to use in a piece of legislation, because what's risky once again to one person, or what's risky in one situation may not be risky in another. So once again, I would say add a subsection which clearly defines what factors need to be taken into account when determining what is risky.
The Chief Parliamentary Counsel Acting, Sean Rain Bell, spoke to Section 40 to give understanding of risk.
Where the parent refuses or is unable to resume custody of the child, where the child is beyond the control of the parent and the child is a threat to himself or others, where the child is under the age of 12 and has committed an offense ordinarily that would constitute an offense but cannot be held criminally responsible, and the circumstances of care and protection as it relates to Section 40 rather than Section 39 of the Child Justice Act.
The Barbados Bar Association's presentation saw Margot Green ask for a redefining of the word child, since 16-year-olds get married with consent. She also pointed out that children are abducted from Barbados and it's expensive for the parents to litigate.
Section 8, which establishes the authority, I was wondering if the authority will also be regarded as the central authority for the Hague Convention. You might not think it, but Barbados has quite a few cases involving children who are abducted and taken away.
Another issue raised by the bar was the definition of psychological pain, and the Chief Parliamentary Counsel replied.
In relation to the definition of psychological pain as not being defined, in terms of the canons of statutory interpretation, you will note that one of them is that where the Act may not provide for specific definitions, then the court is allowed to rely on the ordinary dictionary meaning.
It's back to you now, Ryan.
Thanks so much, Wendy.